I'm Uzo Akpele, an immigration lawyer here in Atlanta, Georgia, helping people navigate U.S. immigration law, no matter where they're located, inside and outside the United States. In this video, I'll give answers to some more questions we're asked about the petition to remove condition. One of the questions is, well, my U.S. citizen spouse has refused to sign the joint petition. What should I do? So the answer is this. If the conditional resident sends in the petition with only one signature, the USCIS will request that the second one be added. If the second signature is not added, the petition is denied, and the conditional resident will be put in removal proceedings in immigration court. However, I do know that refusal of the US citizen to sign is usually a sign that there's a problem at home. But the conditional resident is not without help. You may sign the form by yourself and request a waiver based on one, a good faith marriage which simply failed, or a marriage marked by battery and extreme cruelty to the conditional resident, that is you who are not the US citizen, extreme hardship to you if you were to be removed from the US. Any ground which you choose to use must be documented properly. That means you have to submit evidence up till the time when your marriage ended to submit the good faith of your marriage, extreme hardship, and then, of course, on a continuing basis, the extreme hardship which you would experience if you were removed, if your petition was denied and you were removed from the US. This is one of those situations where you would do well to have an immigration lawyer assist you. Most likely, you're going to be called in for an interview for this one. Another question is, well, my spouse died before the second anniversary of my permanent residence. What will happen in this case is that the law provides for you to just submit your husband's or wife's death certificate and then the other evidence of good faith up till the time your husband or wife died. So that's easy enough. And then another one is, well, I was arrested and convicted of a crime after I received my green card. Well, being arrested of a crime is never good for a permanent resident. However, what will ultimately happen to your permanent residence depends on what you were arrested for and how the case was concluded. For instance, if you were arrested for a simple traffic offense, most likely your green card will not be affected. In those traffic offenses, what's most important is that you should attend the traffic court and pay any fines and complete other terms of the court's decision. As for arrests for other crimes, one's outcome may possibly affect their status as a green card holder. And there may be ways to remedy your situation, but sometimes too, there's nothing else could be done. In such a situation, it is best to speak with an immigration lawyer who will help you analyze and prepare a strategy, because those criminal cases, they tend to run particular to each case. It's really not easy to give a one-size-fits-all advice for each of them. Depends on what one was charged with and what one ended up how one pleaded and how one also ended up the sentence one ultimately received. An immigration lawyer will analyze that. Then there's the people who ask, well, some people come in, they weren't our clients, and sometimes our clients have their petition removed, denied, that is. In such a case, you have options. You can refile your petition with the USCIS. You can defend yourself in immigration court, because immigration, upon denial of your petition, will ultimately refer you to immigration court. So you could also ask immigration to reopen or reconsider your case. Whichever one, we are able to help you in our office. If you have any of these situations, call us and we can assist you walk through it. Till later then. Yeah.